After a string of high-profile ICE detentions of Connecticut students, the state passed one of the most sweeping immigration enforcement laws in the country. It's called Senate Bill 397, officially titled, An Act Concerning Democracy and Government Accountability. Governor Ned Lamont signed it into law on May 4, 2026, at a ceremony on the steps of the Connecticut Supreme Court. It passed largely along party lines, 91 to 53 in the House and 24 to 10 in the Senate. The bill followed the detention of a Cheshire High School student and a nursing student at Southern Connecticut State University, arrests that sparked protests across the state. It also came as the U.S. Department of Justice sued Connecticut and the city of New Haven, challenging the state's existing immigration policies. At its core, the law creates what it calls protected areas, places where civil immigration arrests now require a judicial warrant. That includes schools from preschool through college, licensed hospitals and urgent care centers, and houses of worship. It also covers food banks, homeless shelters, domestic violence shelters, child care centers, school bus stops, playgrounds, and disaster relief sites. The protections extend beyond the buildings themselves, covering parking lots and garages at these locations too. One important detail: the Protected Areas Rule does not take effect immediately. It starts October 1, 2026, a delay added through a Senate amendment. The second major piece of the law gives Connecticut residents a new way to fight back in court. It creates a state civil lawsuit option against federal, state, or local officers who violate someone's constitutional rights, modeled on a federal legal claim sometimes called a converse 1983 action. Third, the law restricts law enforcement from wearing facial coverings while carrying out official duties in public, a rule that applies at every level, including federal agents. Breaking that rule is a misdemeanor, carrying up to 30 days in jail and a $250 fine. If an officer violates the mask rule while committing certain misconduct, like a false arrest, they can lose their legal immunity from being sued. Fourth, the law limits how automated license plate reader data can be used for immigration enforcement. That data can only be kept for 21 days, unless it's tied to an active criminal investigation. Fifth, the law creates a public enforcement dashboard, so residents can track immigration enforcement activity happening across the state. The law also raises training standards, requiring officers to complete at least 480 hours of training to become police in Connecticut. For comparison, federal ICE officers reportedly receive around 376 hours of training. Supporters, including many faith leaders, say the law protects vulnerable people from enforcement in sensitive community spaces. Critics, mostly Republican lawmakers, argue the state cannot legally dictate how federal agents operate, and warn it could hurt law enforcement recruitment. Some opponents predict parts of the law will face legal challenges in federal court. This is not Connecticut's first move in this direction. Lawmakers had already passed the Trust Act, limiting how local police cooperate with ICE. A separate law from a November special session already restricted immigration arrests inside state courthouses. Senate Bill 397 extends similar protections well beyond the courthouse, reaching into schools, hospitals, and community spaces. The legal fight is far from over. The federal government has already sued Connecticut over related immigration policies, and further challenges are expected. Protected areas, a new right to sue federal agents, a mask ban, license plate data limits, and a public dashboard. That is Senate Bill 397. Where do you think the line should be between state protections and federal immigration authority? Let us know what you think.